universities as well are qualified employers. There's nothing that you as the employer has to do to put yourself out there. There's no application you have to submit. There's no qualifying process. You are a qualified employer if you are a private sector employer or a public higher education institution. Excluded from covered employers are the government, basically. Federal, state, and local government employers are not covered and cannot take advantage of this incentive or the tax holiday. So in essence, you're automatically covered unless you opt out. If you don't want to be covered by this, then you would have to formally opt out. I'll explain more about that as we go forward. There's really very few circumstances where you would ever want to opt out. Plus, and I'll mention this again later, you can decide not to participate in the program. You don't have to apply for the tax incentive or take advantage of the tax hiatus. You can choose to do that or not. You don't have to opt out to not participate. If you don't want to take advantage of it, if you hire people and don't want to deal with the administrative side of even applying for these benefits, then you simply don't do it, but you don't have to opt out to do that. Really, there's only one circumstance, I think, where an employer will officially want to opt out, and I'll explain that in just a few minutes. So that's how you become a qualified employer, basically by continuing to do what you're doing and simply being in business. Then we also have to look at, who's a covered employee. How do we define a qualified employee under this higher act? Well, I mentioned a little bit at the beginning that you need to first be employed during a certain time period. So to be a qualified employee, you have to be hired, you have to begin work for a qualified employer after February 3rd and before January 1, 2011. So that's one component. You also have to, the employee also has to, this new hire that is, has to sign an affidavit under penalty of perjury that she was employed for a total of 40 hours or less during the previous 60-day period ending when employment starts. And what's the reason for that? Well, the statute is intended to put people back to work, not just to create an incentive and a tax benefit when an employee switches from one job to another when they were already fully employed and decided to change jobs. Yes, it's a new hire and they're beginning work for a qualified employer, but it's not the kind of hire that we're talking about here to take advantage of these tax benefits. So they're really trying to put people who have not been working or were very underemployed back to work on hopefully a full-time basis or on a regular basis. So that employee will have to sign this affidavit acknowledging and attesting under penalty of perjury that they had worked 40 hours or less during the entire previous 60-day period. So it's not 40 hours a week, it's 40 hours over that entire 60-day period. If they worked less than that, then they can be a qualified employee and you can take advantage of these opportunities. Also, it has to be an employee who was not hired to replace another employee. At least that's the way it's phrased at the beginning. So the idea again here is to not just take advantage of the tax break when you're replacing an existing position. They're really trying to get employers to hire more people to take advantage of this opportunity. But it's interesting phrasing in terms of what the law tells us and the guidelines that the Internal Revenue Department has told us about, in that they say that there can be a qualified employee if they were not hired to replace another employee unless such employee voluntarily quit or was terminated for cause. So if the person that you're hiring is replacing someone who voluntarily quit or is terminated for cause, then arguably they will become a qualified employee. We don't have any law around this yet because it's a brand new statute, but it's interesting to me as I think about that, how many other opportunities would you actually be hiring somebody other than if an employee voluntarily quit or was terminated for cause? Are you going to acknowledge that they were terminated but not for cause and then not take advantage of the tax credit? So it's interesting phrasing, not entirely sure what all that will mean in terms of how it plays out, but those are the words that the IRS has told us apply in determining whether or not someone is a qualified employee. And then lastly, the person that is being hired cannot be a family member as defined by the Internal Revenue Code section 51I, and I'm not going to go into that entire part of the Internal Revenue Code, but that Internal Revenue Code section does define specifically particular family members, and so we'd have to look at that specifically to decide what kind of family member will not be covered by this particular statute. And it's basically individuals who are family members the way we would normally understand it, a brother, sister, sibling, individuals like that, spouse. Those are the type of family members that the IRS tends to exclude and will not be covered by this qualified employee definition. If you need more specifics on that in terms of a particular hire you're looking at, then we can talk to you more about those specifics and apply your particular facts to the law as it's written right now. So those are some of the beginning issues that we look at in terms of evaluating whether or not someone is a qualified employee. In terms of looking at this kind of from another perspective, we're basically then talking about in persons to be a qualified employee who are new employees, employees who were previously laid off or terminated by an employer but are rehired and meet the 60-day requirement can also be a qualified employee. So you might have someone who you laid off, say, the end of 2009, and that person did not work, and then let's say you then hire them this week. And in the past 60 days, they can sign an affidavit saying that they worked 40 hours or less during the past 60 days. That person can become a qualified employee because they are essentially being rehired from a situation where they were either not employed or underemployed during the last 60 days. So even someone who's worked for you before could arguably meet this definition of a qualified employee. Also, if you're a startup organization, you're a new business, and you're hiring people for the first time, then that as well can meet the definition of a qualified employee under this Hire Act. Students also can qualify. So individuals who really have never even been in the workforce yet, but are coming out of school and again meet the definition of having worked 40 hours or less during the last 60 days will also qualify under this definition of a qualified employee. So there's a whole host of different types of individuals who can meet this definition and for whom you can take advantage of these opportunities. The form that we had up there just a second ago, we're going to get it back here in a second. This is the form that was created by the government, by the Internal Revenue Commission, the IRS, that allows employees to sign, that creates a form that you can use for the employee affidavit. As you can see, it's a very simple form. It's really the top half of the form is what the employees will sign, and that it's very simple. And so you can have the employees sign that form, and then you keep that as the employer in your files. But you do not have to use that form, even though that's a very simple form and can be downloaded from the IRS website. You don't have to use it. You can design your own form, your own affidavit, and as long as it has the same information that is on that W-11 form, and the employee is signing under penalty of perjury and acknowledging that they did not work more than 40 hours during the last 60 days, then you're fine. The affidavit is not